I'm going to try and do is introduce the subject, talk about costs of violence, what it actually means to the different forms of violence that exist against women and girls, because the convention also covers girls, what the Istanbul Convention provisions are, some of the overviews, and some legal implications of accession to the EU for it. Sounds good, doesn't it? So, according to the Fundamental Rights Agency of the EU, that did a survey of 42,000 women in the EU in 2014, 1 in 3 women in the EU have experienced physical or sexual violence since the age of 15. 1 in 20 women have been raped. 75% of women in qualified professions or top management have been victims of sexual harassment. 1 in 10 women have experienced stalking or sexual harassment through new technologies, so online. Over half of women have experienced sexual harassment, and 1 in 3 women have experienced psychological abuse, abusive behavior by a partner. The list goes on. It's more than this, but those are just some of the headlines. Now, the Gender Equality Institute in Vilnius has commissioned a study and has come up with a figure, and I think it's probably an underestimate because it's very difficult to estimate these kinds of costs. However, they say that gender-based violence against women generates costs in the EU of approximately 226 billion euros per year. So if we reduced violence by just 10%, then it would be 7 billion a year saved. If you can imagine what you can do with 7 billion for poorest of us in the European Union, that's a lot of money we could save. So one of the reasons that this presentation exists is to look at the effect on different genders of violence and also what we can do to reduce the level of violence. Now, it's very difficult to go to work when you're worried about what's going to happen when you get home, whether you can be effective in the workplace or whether you lose days off sick because you have a broken arm or a black eye or your child has been abused, whatever. Yeah? So this impacts on the workplace as well, and on gender equality in particular, because what we're really talking about is mostly, not only, but mostly male violence against women and girls. So the Istanbul Convention is a Council of Europe convention. So it isn't strictly European law, but I'll explain to you why it intersects with some of the things that you might be looking at in your practice and why it might be of interest to you while practicing gender equality law. The Istanbul Convention was signed in 2011 and it came into force in 2014, so it's already 4 years old, nearly 5 years old. By October, late October 2018, only Russia, what a strange surprise, and Azerbaijan have not signed it. There have been 33 ratifications in the Council of Europe of 47 member states, but there are 21 reservations already. And reservations, as you may know in international law, mean that they decide that certain provisions of the treaties will not apply in the member state for whatever reason. We don't have time to go into those reservations, but generally we're talking about extraterritorial, a word I can't pronounce, extraterritoriality, so where the convention will apply. So if somebody goes on a tourist visa or tourism to Thailand, if they abuse a little girl over there, when they come home, will they be prosecuted under the Istanbul Convention or under domestic criminal laws? That kind of scenario is very common, the reservations. Now, there is a comparison that was made, and it's a really good document, and I urge you all, of course you've read it already because you've had this since yesterday, a document that compares the provisions of CEDAW with the Istanbul Convention. Why that is important is what you were talking about and others have talked about yesterday as well as today, is that the provisions in CEDAW allow, for example, temporary special measures to be enacted in order to help progress the the negative position of women and girls in society, including righting past injustices, which still exist. So this is just a slide to give you an idea of what it covers. It's a very long treaty, actually, and it's very prescriptive. And it focuses on prevention, which is a very key important provisions, because we want to prevent violence from happening in the first place, rather than remedying once it has happened and clogging the criminal courts. So you can see it's quite wide-ranging, talking about prevention, protection, support, substantive criminal laws that member states are asked to sign, investigation, prosecution. So it's an awful lot about criminal law, but it's also about migration and asylum. So migrant women are specifically mentioned in this convention, which is very, very unusual for international conventions of this kind. International cooperation, so it's a transnational convention as well. And importantly, there's a monitoring mechanism, which looks at member states and how well or badly they're doing compared to these articles within the treaty. So the Istanbul Convention is based on the understanding that certain types of violence is a manifestation of historically unequal power relations between women and men. So women traditionally haven't had a great deal of power within the public sphere, so their positions, therefore, and all the institutions that have grown up had been designed for and by men in general, not always, but mainly. And those past inequalities have had an effect, a lasting effect, and trying to right those wrongs is what some of the Istanbul Convention is about. And remember that it was negotiated in the early 2010s, so it was signed in 2011. So we're talking about at the very beginning-ish of the financial crisis. So it's not something that's been in the past, like the CEDAW Convention 1978-79. We're talking about right now. So there is still a recognition by member states, many member states, that there are these inequalities, and to try and right the discriminatory practices against women. It permits special measures. We just talked about women on company boards. Those kind of special measures are also permitted to protect women. So, for example, having single-sex services that women are able to access safely. And big issues around trans women are very current in the UK, at least, where we're trying to work out what do we do with a woman who identifies as trans, whether we allow them into these specialist services or not. This is something that might come up in your practices as well, or you might want to have a think about. Now, why am I telling you about international law? We're talking about EU law here. However, now, depending on whether your country is a monist country or a dualist country, and of course you're all familiar, but I'll just remind you, a monist country is one where you don't have to pass an act of parliament into your and to pass the international treaty into domestic law, whereas a dualist country is where you have to pass an act of parliament, in your member state, and then it becomes incorporated into domestic law. It's mixed in the EU, but despite whether you're a monist or dualist country, there is such an obligation on member states of international treaties, once you've ratified it, to have due diligence to the obligations in the international law, which means the member states can't get away with it. They can't just ignore international law because they've ratified it. So you can use it as a private individual. You can litigate on the basis of that, even in domestic courts, saying that once a member state is made aware that there is this problem of violence against women and girls for the specific scenario that you're talking about, then they have an obligation to investigate, prosecute, and do something about it. Every state has an obligation to provide its citizens an area that is free of violence, whether it's male or female. So this due diligence obligation can be used in your domestic courts. It does cover the media and civil society actors, so it's not just the state or manifestation of the state in EU terms. It's also the media. If they misrepresent women as always being victims of these violent crimes, for example, you might be able to do something about that. So it might be quite lucrative. Don't know if you're motivated by money or not, but might be something to think about. So there are an awful lot of slides that I've done. I pride myself in doing too many slides on purpose because I just love slides. I just think they're great. Anyway, so I won't go through all of this. You can all read it here. Hopefully you can take it away. You can always email me questions as well. But it's to give you an idea of the purpose for the convention. And this was really a hard-fought convention, we nearly didn't have it because of the gender issue, and I'll come back to that in a moment. But basically, it's there to protect, prevent, and prosecute, and to eliminate violence against women. It's to promote international cooperation, and it's to support and assist victims. It's an integrated approach. It's an intersectional approach. So there is a specific monitoring body as well. The convention applies to all forms of violence against women, and women here is interpreted to mean girls as well. So girls under the age of 18 are also covered. It also includes domestic violence. Now, why is that separated out? Because all forms of violence, should also cover domestic violence, which is the most prevalent form of violence that we have in the world today. It is the #1 human rights violation in the world, despite the number of conflicts we have around the globe still. Domestic violence was a hotly contested issue because the convention, many member states just wanted it to cover domestic violence and nothing else. So they separated it out to make sure that men who were suffering from domestic violence were also covered. So it is gender specific, this convention, in parts only, and gender neutral in other parts. So you have to sort of divvy up whichever provisions you're looking at, and it's detailed in the convention itself. Parties are encouraged, however, to apply this convention to all victims of domestic violence. Parties shall pay particular attention to women victims of gender-based violence. Okay? And it applies in peace and in armed conflict as well, something that might become more relevant as we go on into the century. Sorry to say. So it has a definition of violence against women, which I'll leave for you to look at, but it includes a form of discrimination, hence why it's on the program here. So it's understood as a violation of a human rights and a form of discrimination. So when you batter your wife, you are perpetrating an act of discrimination. Yeah, so that's what the convention actually says. So it could be physical, sexual, psychological, economic harm or suffering to women, including threats. So threats are covered. Inchoate crimes are covered. Coercion, arbitrary deprivation of liberty, so locking someone into the house, for example, whether occurring in public or in private life. So it's very important that this last part is covered as well. In international treaties, they usually just cover the public, but here it's the private as well. So you can look at domestic abuse here. And of course, we know that psychological harm often is much more damaging and long-lastingly damaging, lifelong probably, especially when it occurs with children, or if children see the domestic abuse that the father perpetrates against the woman. How can a child go to school and have great grades if they come back and they're faced with this kind of violence? It's very, very difficult, problematic. It's a societal problem that the Istanbul Convention tries to recognize. So we have a definition of domestic violence. I won't go through it because you can see it yourself. There's nothing in law that is particularly problematic. It's been in domestic law for a long time. Gender, however, is one thing that has been defined. Here it's probably not a problem at all, but it means the socially constructed roles, behaviors, activities, and attributes that a given society considers appropriate for men and women. So it's a social construct. And that will change over time, and it is changing already with the inclusion of trans. It doesn't mention that here, but I would imagine that that's going to be more prevalent as the days go on. So I'll leave that for you to have a look at. So Article 4 talks about fundamental rights, equality, and non-discrimination. So this is an international treaty, human rights-based, not crime control model, as for example, the Human Trafficking Convention at the UN level is, or at the UN level is. This is about human rights and protecting people's security. So it is for the state parties to take all necessary legislative and other measures to promote and to protect the right of everyone, particularly women, to live free from violence. That's a pretty great thing to live up to, isn't it? Wouldn't that be great if we had that? Parties should condemn all forms of discrimination. Now, this is all very parity from Article 2 of CEDAW, so we're not inventing anything new. All the EU member states have signed up and ratified CEDAW, which is passed in 1979, it's a UN convention. So there's nothing radical here. It's a restatement, like the EU Charter is, of the fundamental values that we espouse to in the European Union and we're willing to litigate and fight for. That would be my take on that. It also allows special measures to be passed that are necessary to prevent and protect women from gender-based violence and shall not be considered discrimination under the terms of the Convention. So it's much more liberal, if you like, than what you were describing earlier, I would suggest. And it also mirrors the temporary special measures clause within CEDAW, which again is much more liberal. You can use it quite well, I think, in national law to help women get to that level playing field and maybe slightly ahead. Is that controversial? Would be nice, wouldn't it? State obligations and due diligence I've already mentioned, but importantly for you, maybe for practice, is that you can ask for reparation. And reparation is a catch-all phrase or term that is not just about compensation. It could be other measures as well, putting the person back into the position that they were before they were, you know, battered or put in hospital or whatever it might be. So reparation is a wider term than just compensation. So you'd have to have a look at your member state's domestic law in order to figure out exactly what kind of measures that you can utilize. But certainly if you have a discrimination case and you see that the woman has been kicked about a bit as well, then maybe you can do something with the reparation clause in here too, and add that to a claim, possibly, or a separate claim as well. So do remember that. Because it is also about not just the workplace, it's about non-state actors. So that's private individuals. So if they, for example, volunteer in NGOs, in charities, or if it's the next door neighbor, anything like that, you can ask for reparation from them as well, so you can take them to court. The parties shall undertake to include gender perspective in the implementation and evaluation of the impact of the provisions and promote and effectively implement policy of equality between women and men and empowerment of women. Empowerment of women means advancement of women. It doesn't just mean not doing something. It's not just a negative duty, it's a positive duty to help them up, you know, put that ladder there and help them up to get to a position of equality. True equality, substantive, transformative, substantive equality. Data collection has always been an issue, and IGA, the EU Gender Institute, has started data collection on ending violence against women and girls. It's getting there, but it'll take a little while to collect that data. But disaggregated data is the key thing. And disaggregated not just by gender, but also by race, ethnicity, sexuality, and all the other protected characteristics that exist. And it's important to get that information in order to shift society's view on this. And I think the 2014 survey, FRA survey, was a major shift, knowing how many people, how many women in particular, were being, had gender-based violence perpetrated against them, was definitely a shift. So it's about shifting the culture in society and ridding it of the prejudice and customs and traditions. So, for example, female genital mutilation. That's one aspect. And the practices that are based on the idea that women are inferior, or on stereotypes. And stereotypes, as we know, are very, very damaging in society. Not just for women, but also for boys, especially in pornography, for example. So it covers the private sector and the media as well. It's very wide-reaching. Protection, information for victims. I think that probably a lot of member states, there's a lack of information to victims once they have been, let's say, raped or domestically abused, about what is available to them and what remedies they can get. So how can they go to the police? How can they access services? And this is not just one member state's problem. It is worldwide. So information, making it an obligation for states to provide information to victims in the language that they can understand, by the way, is very, very important. And that's why I've highlighted here. But that's beside all the other important things here. Now, I do wonder if all of your member states have telephone hotlines. for domestic abuse or gender-based violence? I bet there aren't every single member state. And I know in Germany, it wasn't until about 5 years ago that there was a hotline for domestic abuse, which really surprised me. Such an advanced country as Germany, and it didn't have a hotline. But, you know, but this is something that is cultural as well. So it's really good to have these measures in international law and transposed international law so that we have a uniform system of what we know what works. Rape crisis centres as well. The austerity measures that have been put in place, a lot of rape crisis centres have been closing. A lot of victim support systems have closed down. Now, once you have had those things, they're no longer an entitlement, they're no longer a privilege, they're a right. So once the state has provided those things, so by acknowledging that there is a need for victim support services, the state has an obligation to keep providing them, regardless of the economic situation. That's a tough message to get across, right? Because they're just going to say, oh, we have no money, you know, we have to do other things. It's absolutely understandable. It doesn't mean to say that they can close the victim support services, though, because it's a right, not an entitlement of citizens, because of your due diligence obligations. Does that make sense to everyone? Yeah. So that's another avenue that you can use to try and get them to reopen them. So the substantive law areas in Part 5, there are civil law cases and remedies that you can get in compensation and reparation, as I said. There are also civil consequences of forced marriage. I don't know how many countries here have criminalized forced marriage, for example, and have criminalized psychological violence. Not every member state in the EU has done that. Stalking, physical violence, sexual violence, all of these things. And forced abortion and forced sterilization, which has been a problem in certain countries, more further east especially. But certainly in Northern Ireland, there is no right to abortion, for example, in the UK. There has been a case in the Supreme Court, they couldn't hear it. So there are disparate laws on this. It's not forced abortion, but it's abortion. These things can be regulated, and they are within the Istanbul Convention, so it's really worth having a look at those provisions. The same thing for investigation, prosecution, procedural laws and protective measures that you can ask for before a court in order to help your victim or survivor get through the ordeal, or get her out of the house, or maybe get him out of the house. Now, there are varying levels of protections within member states' own domestic laws, but this is a minimum requirement. And if you don't have these things, then you can request them once member state has ratified them. I'll come back to ratification in a minute. The statute of limitations is always a problem. It has been a problem for EU law, I think, especially for equality law, and I disagree with that it should be left to member states personally. I think it should be regulated generously at EU level, because it's disabling laws, it's not enabling laws, I would call them, equality laws. So I think that would go a long way to enable people to take cases to remedy their past injustices. And then you've got residency status, and that's becoming more and more acute now with the migrant crisis, as so-called, or seeking asylum. And it recognizes, very importantly, gender-based asylum claims that are subject to Article 1.2 of the Refugee Convention of 1951. So recognizing that in law again reiterates the importance that there are so many women who, within the migration chain, when they're crossing from wherever it is to wherever they get to, how they are being abused. And there are a lot of human trafficking victims now within the asylum-seeking caravans, if you like, that it's getting very, very bad. There was a lot within the camp at Calais as well. Really difficult measures there. Okay, so these lovely people were the first to be on the Grevio Committee, and the Grevio Committee is the monitoring body of the Istanbul Convention. So this this convention doesn't have a court attached like the ECHR does, but it has a monitoring committee. And they go into member states and say, oi, what are you doing about the Istanbul Convention? Are you okay? Are you fit? Is it fit for purpose? What else do you have to do in order to progress the provisions there and make it safer for women and girls to be in the country and for men? And they have various different functions and powers, like monitoring, writing reports, publishing reports, doing special inquiries. So they can, like the CEDAW Committee of the United Nations, go into a country and say, there's a bunch of people who have been, have had gender-based violence perpetrated against them here. Why is that? And it would be very damaging to the country if they were to go ahead and do that. A classic example is Ciudad Juarez inquiry of the CEDAW Committee, which found bunches of women in mass graves because they had been trafficked for their organs, but also in brothels, and then dumped in mass graves once they, were a bit older, like 20, I don't know, whatever. Yeah. Okay, I'm making light of it to try and. They also have the power to have general recommendations, and if you see the monitoring mechanisms of UN treaty bodies, general recommendations are really helpful because they interpret the law and give guidance about the law. So these mechanisms are really great. They're soft law. They're almost equivalent, if you like, to travaux préparatoires. So you can use them in your court proceedings, and you should really, because, for example, CEDAW says you should be using temporary special measures. You should be progressing women. You should have gender-specific legislation passed. It's not that you can, but you should do it in order to remedy past injustices. So they're saying proactively do something about it. Again, we don't have any yet because it's fairly new, but we'll see what they come up with. And then a questionnaire about how well they're doing. That's the usual template that is used to see how member states are progressing in implementing all of the provisions within the treaty. So at the moment, we've got 50 members on this monitoring body. It's gone up from 10 already because there have been 22 ratifications. And it met for the first time in 2015, so it's very, very new. It's taking baby steps. But it's already done 6 country reports. It's received 13 country reports so far. So it's issued 6 and it's received 13. That's a heavy workload for 15 people or 10 people. It's very labor intensive, but well worth it, having a look. Okay, you okay with that? Yeah? Cool, all right. We're on the last stretch now. So just a few legal implications of accession if the EU actually accedes to the Istanbul Convention. It has signed it, and it signed it in June, I think I've got it on a different slide, of 2017, I think it was. But there is, I'll follow these instead, poor interpreters. There is precedent for signing up and ratifying international treaties, and the EU has done so with the United Nations Convention on the Rights of Persons with Disabilities, which is a very, very good international treaty and provides an awful lot of protections for people with disabilities. It's a newish convention, so it's much more human rights based. It's got good practice guidance in it, and civil society has helped write it, which is very important as well, because then it ensures it works on the ground as well. So there's a declaration of the division of competencies that is needed in order to figure out how this will work. How do you get a UN convention to work with the EU treaties, etc.? And that declaration exists for this UN convention. And we'd need the same sort of thing for the Istanbul Convention. So in October 2015, the European Commission issued a roadmap. They love roadmaps, don't they? On possible EU accession. In March 2016, the Commission issued 2 proposals for Council decisions, signing it, or ratifying it. I wish I got paid for that, but anyway. The Council divided the first decision into judicial cooperation in criminal matters and asylum and non-refoulement. And why do we have that? Well, of course, 2016, it's a political thing. Yeah. These 2 Council decisions were adopted in May 2017, and the EU signed the Convention in June 2017. That's as far as it's gone, because progress is pretty slow at the moment. There are discussions taking place in Working Party on fundamental rights, citizens' rights, and free movement of persons. but we need a code of conduct to figure out how we can divide these competencies up and how we can cooperate. There is strong opposition by some governments, and the Bulgarian Constitutional Court held that ratification would be unconstitutional last summer. So that's a major block there. Slovakia would do the same probably as well. It's a difficult time out there. It's difficult. But never give up hope. Nevertheless, she persisted. There you go. The Austrian presidency did say that it would try and do something about ratification in the second half of 2018. And when's the summit? We're coming up to it. So watch this space. Cross everything. Toi, 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 you say in Germany? Yeah? Yeah. So Kevat, I can't pronounce her last name, Nusiainen, yeah, and Christine Chinken, who's a lawyer from the UK, but also helped write the Istanbul Convention. They wrote a legal opinion about possible accession to of the EU to the Istanbul Convention, and it's quite a lengthy document. But if you want the definitive answers, go there, do that. That's fantastic. And I know that Kevat has spoken here at the ERA about it as well. There is a legislative competency to pass the Istanbul Convention or ratify it within the EU. And it exists here, and I've put down quite a lot of the different provisions which would help. So as a gender equality and crime prevention model, these things are part of the EU acquis already. So the EU has general competence to accede to the Istanbul Convention. So I don't think people will be necessarily saying, well, you can't do that because of subsidiarity. There is enough precedent for it. And you can see it in these following slides. So you've got Article 19, Article 157, And then you've got criminal law, you've got freedom, security and justice, justification, promoting equality between the sexes, combating sex discrimination. So it doesn't have competencies with substantive law requirements. And what tends to happen with international treaties anyway, if a member state or a state party is so inclined to ratify it, and there might be political pressure to do so from various parts, then they will pass domestic legislation that is in line with the obligations of the international treaties. So Germany did this, various other member states did this as well. UK hasn't ratified it yet. What's new? We keep pushing them, but has signed it. So that's usually how it progresses. So you have domestic legislation passed, and then they ratify it, so that they preclude lawyers like yourselves going to court and saying, oi, what about... But there's always loopholes. They've always leave things out. Okay, so that's what this is about. So there is also secondary legislation which exists, so the Victim Directive, the Anti-Trafficking Directive, Sexual Exploitation of Children, European Arrest Warrant, blah, blah, blah. So you have a lot of these things that already intersect. It's nothing new in particular and radical that is being proposed. It's just that it's another international treaty obligation. So we've got the potential of increased case law, which is great for lawyers, right? Because we get paid for that, that's fantastic, to end violence against women and girls. And it clashes maybe with other rights, for example, between the accused and the accuser, the EU Charter of Fundamental Rights, how it intersects with it, the prevention, protection, assistance, right to a fair trial, so you can utilize those provisions as well. The enforcement proceedings, where provisions of the Istanbul Convention have not been transposed or transposed incorrectly, just like direct effect or indirect effect as well. And of course, the enforcement of the due diligence standard, which we have case law of the European Court of Human Rights, which we can use because of the EU Charter and the protocol that attaches between those two courts, that you have to recognize and promulgate the judgments of the European Court of Human Rights. And there are a lot on this subject, on gender-based violence. Opus is one, RANCEF is another, but there are many, many different ones. Okay. And then there are some challenges, and that is not all EU member states have ratified the Istanbul Convention, and I've mentioned a couple of difficulties there. Substantive criminal laws still need to be compliant with the Istanbul Convention. That takes a little bit of time when political parties are not looking at this specific issue. They've got their eye on something else. And you need adequate funding as well for specialist services, and that's always an issue. But they need to do it in order to comply with the convention. Migration and asylum is a difficulty because it asks for a residency permit, and a lot of member states are unwilling or unable to do that at the moment. There might be political will for some things, but not for others, and there are a number of reservations as well. So, gender ideology is a particular problem. That's what the Bulgarian Constitutional Court or political parties were wondering about. Now, does this convention open up the possibility of same-sex marriage or recognizing trans people? Wouldn't that be shocking? Well, they're human beings. Everyone's a human being. So this Istanbul Convention doesn't talk about that at all. But we have scaremongering all the time, don't we? Well, we're here as equality lawyers, so I'm not too worried about you being worried about gender ideology, right? About whether trans are covered or not. Violence is violence is violence. It doesn't matter who it's perpetrated against. And if you permit me one last sentence, and that is, step into your power. Tomorrow's promised to no one. Thank you very much for your attention and staying to the end.